This is a noble profession, has been, is, and will remain as such. And you cannot cut corners. The first term, he said, well, what you think now is a handicap will one day become your greatest force. If you beat about the bush and you're trying to
evade the question,
they put you the question twice, but there won't be the third time.
Sanjay, good afternoon and welcome.
Good afternoon and thank you so much, Joanne.
It's a pleasure to have you. I think we've only had one other senior counsel on this podcast before, Patrice Despéville. And one of the reasons I reached out to you is that you've always struck me as someone who's always made time to teach, to mentor, and for others generally. How do you, in 2024, when we have over 1,000 barristers at the bar, at the Mauritian bar, how important do you think the role of mentoring is?
It's essential. Let me say especially why. See, many of our young colleagues who are sworn in at the Mauritian bar have done their studies abroad. So as we have, and in fact you have spent more time,
yes,
much more time than I have in the UK after having graduated, you work there. So let's on average after 4 years of graduating from law school and then the bar, the young colleagues need time to readapt to the country, in the profession, and socially, so at different levels. So in this respect, I believe that mentor, or as we call it here, a pupil master, has an essential role to play to assist that young colleague in undergoing that transition period with as much ease and smoothness as possible. So this is why, ever since I qualified to be a pupil master, which is 10 years standing at the bar, I've always had pupils. Just to give you an example, I had my first pupil at the age of 34, and my pupil was 27.
Oh, wow. So there wasn't a big age gap, yeah. Oh, wow.
And in those days, pupillage used to last 9 months, whereas now it's staggered over maybe 2 or 3 pupil masters. And speaking of which, one of my first pupils is now a judge of the Supreme Court.
Really?
Yes. When he was appointed, he called me and said, Mr. Bhuckory, I'd like to thank you. I said, well, why? He said, because I've just been appointed a judge of the Supreme Court and I wish to place on record my recognition. That was very touching. Very touching. I said...
Because it would have been years later. It would have been, 15 years or 20 years later? But, yeah.
Yeah, that was around 1996. Yeah, around 1996, indeed. 95, 96. So that would have been like nearly, 25 years at least later.
Wow.
Yeah.
Wow.
And I said, call me Sanjay. He said, no, I've always called you Mr. Bhuckory.
Really? Even as a judge?
You see, so this rapport, you see, this is perhaps by way of an answer to your question, this mentoring, that special relationship and that bond, it remains throughout one's career. But above all, I believe that there should be a mutual respect. See? Respect in the sense that a pupil master needs to make time for his pupils. I'm appalled, Joanne, at the fact that some pupils don't even meet their pupil masters. Some others, they are made to undergo pupillage with pupils or junior members of the bar. You see,
so the
at the
pupil
chambers,
master is just on record?
Just on record. This is deplorable. And I've always been making representations to the authorities that this should be strictly controlled. because it's most unfair otherwise. You start off by saying that one should make time, indeed. This is the very essence of this noble
I think we often
role.
forget that it's meant to be a noble profession.
Exactly. And these are, I said, to repeat myself, young members of the bar who need to acclimatize themselves with the profession, with the country,
Yes.
and with the decorum and so on.
And the culture as well, because
Yeah.
you know, often you feel, I mean, I'm not in Port Louis. I know there's a different vibe in Port Louis. And one question that would be quite interesting to see your point of view on that is, do you think, you've been a pupil master for so long now, when you look at today, do you think they are too impatient now, the young callies?
Well, the world has become more impatient. The country has become more impatient. This is a sign of times. Well, you see, if they are, this is a reason, an additional reason why we should be here to rein in this impatience, to show them the way forward and to, you know, I wouldn't say calm them down, but at least to canalize this energy.
Yes.
You see? Yeah. True it is. I mean, just to be more on a more serious note, maybe. Not that I wasn't serious. You see, the attitude of a quick fix, you know, of immediate results, this is a sign of times, inevitably. But the profession hasn't changed in this sense. It's remained static, thank God, because there is no reason to change. The rules are what they are, the ethics are what they are, and there is no shortcut. So this is hence a further reason why they should be made to understand that, look, this is a noble profession, has been, is, and will remain as such. And you cannot cut corners.
Because I think also, you know, going back to the nobility of it, with modern times where now you have structures of law firms as opposed to simply chambers, and law firms have been around for over 10 years now. I mean, we are a law firm, so I'm not saying law firms shouldn't exist, otherwise we wouldn't exist. But there's also a danger to veer into seeing it purely as a business rather than, as you said, a vocation and a noble profession. So how do you, again, guiding the junior barrister, how can they be encouraged to think of it as the noble profession that it is, that to remind them of their primary duties under the code of ethics, as opposed to, I'm not saying everyone should work for free, but just to see it as a profession as opposed to simply the business of doing law?
Well, the advent of law firms, as you said rightly, Joanne, has brought about some changes in attitude, I must say, in the sense that a lawyer within a law firm is not exposed to litigation necessarily. Generally not, it's more transactional work and advisory work.
Yeah.
They may have their, litigation department, true it is, but they are generally around a bend where you are, and not necessarily in Portly where, as you said, le chaudron, this is where everything is happening. But nonetheless, we have a common denominator. It is the nobility of the profession that doesn't change, because even in your day-to-day dealings with your clients who are normally not necessarily resident in this country, the principles are the same. First of all, you must ensure that you're not conflicted. Secondly, you must dispense legal advice to the best of your ability and do so without conspiring to commit a criminal offense or to bypass some legislations, especially tax. You who are a tax specialist, you should know better.
Exactly.
There is sometimes a very thin dividing line, isn't there? Between tax advice, tax evasion, and like. All this meaning to say that, and this is the advice I normally give to my pupils and the young ones who eventually want to, make a career in a law firm as opposed to a firm of chambers, which is normally into litigation and also into advisory, is that, look, do not think that your standards would be lowered simply because you're not confronting the courtroom, the judges and magistrates, where there is another rigor because you are there being reminded day in, day out, see, of the reality of the code of ethics. Whereas once you're in a law firm, because you're left to yourself within the comfort of a different legal reality, you may think that, well, those standards that you supply do not apply anymore.
Right, yeah.
And I believe in this sense that the heads of law firms, which I'm sure you do yourself, Joanne, should constantly remind their juniors of the need to keep the same rigor and the same discipline.
Yeah, no, that's excellent advice. Thank you for that. I should probably have asked you that as a first question, but have you always wanted to do law?
Well, I studied sciences at the Royal College, chemistry, physics, mathematics. I was destined to be
a doctor?
No, an engineer, structural engineering. That was a new course that they had started at Imperial College. I was already offered a seat to do structural engineering at Imperial College. And then I watched a film. I can't recall the title. It was a black and white film, British film, which was about a barrister and his female client, and it was a battle of wits, of the mind, of philosophy, morality, guilt, and so many questions asked, so many answers and so many non-answers also. That made me change my mind. Then I applied to read law at the LSE.
Just from a film?
Just from a film. Just from that encounter between a client and a barrister. And that made me change my mind. And so I was accepted at the LSE, thankfully, and then
And the rest is history.
Ongoing history.
Were you at any point when you started the course, did you ever question whether you made the right decision?
I did question, because in those days, pure science subjects were not of the order of the day. I was the only one in the faculty who had read sciences. Wow. All the other students were art students, pure arts, and many of them were degree holders already. So that was very tough. Obviously, I had to adapt to the language, because it's more literature, And then I had a professor, John Griffiths, who was an expert, a specialist in constitutional law. I went to meet him one day, so I expressed my apprehensions to him. That was at the end, of the first term. He said, well, what you think now is a handicap will one day become your greatest force. Your scientific mind should be put to good use. Don't worry about the reading. You'd learn to read quicker and to assimilate. But you have an advantage over your other colleagues in that you can rationalize much better in a more scientific manner. I followed his advice. I struggled a bit, in the first 2 terms, but then I made it among the top students at the end of the degree. Wow. Yeah, and to date, I keep that at the forefront of my mind. And
someone said that to me a few years ago. Unfortunately, he passed away now. But I remember he said to me that he was encouraging his children to read law, but that he wanted them to do science subjects at school, because it prepares your brain in a different way. You'll have all the time in the world to read after.
Yeah, exactly.
Wonderful. And I understand both your children are lawyers. Was there a bit of a push on your side?
Well, let me say, speaking of science subjects and my children, my son, in fact, was a science students. And like you, he was a scholar of what we call the laureate of the State Scholarship of Mauritius. And he went to read law at University of Cambridge, and now he's a solicitor. My daughter, she read geography.
Really?
Yeah, geography and English and French. She wanted to do a degree in geography, and I encouraged her because I realized that a non-law degree was an advantage. But then somehow, in the course of the process, she changed. She read law. She was at Bristol University, and she went to the bar, and now she's joined me at my chambers since the past 2 years.
How do you find working with her? Does she challenge you?
Well, we happen to live under the same roof, so you can imagine the intensity never dies down.
I'm sure.
The intensity never dies down. But I suppose history is repeating itself because my father was a barrister too.
Right.
And except that I didn't work with him when I came back, we worked separately, but at home we were together. We were endlessly debating, exchanging and debating. No, but to come back to your question, Joanne, I mean, no, I have surely not influenced them at all. In the case of my son, he was destined to be an actuarian. Then the Privy Council came to Mauritius. That was on the rare times that they came here. I had a case. I was appearing before them. I took him along. It was his Easter break. Just like me, it took a short few minutes to change his mind. When he saw how scientific the judges were in their approach, the law lords, okay, through the exchanges, he said, I've made up my mind, it's going to be law.
That's so incredible.
My daughter had never changed her mind. Ever since she could speak, it said she would become a lawyer.
Really? So she must see you as a role model. She must do.
I suppose you and your husband also, Jonathan is a very close friend of mine.
Yes.
You must be, doing things, maybe also inadvertently for your two children.
Well, I wouldn't like them to be lawyers, but I've always said to them, whatever makes them happy. They're still very little, so they'll have time to. Although, we were discussing with the future of the law with another barrister the other day, Eric Rebaud, Jr. And, that's a question I often ask myself. What would the practice of the law look like in even 20 years? I'm not saying that courts will be replaced or the judiciary or even lawyers, but I think the way we practice law will radically change. But I can't picture it. It's hard for me to try to gauge how it will look like.
Let me maybe try to take that as a question. That was a reflection, but I'll take that as a question.
Indeed.
Already what I can say is that of late in Mauritius, there has been a fundamental change in terms of the approach of the court requiring written submissions to be furnished. As you probably know, formerly it was only in appeal cases that used to be the case. In fact, we have the rules of the Supreme Court to provide for, the necessity to put in written submissions, what we call skeleton arguments. Then that started to be extended to trial cases, merits cases, and then eventually to chambers cases, because in chambers cases, all the pleadings are already closed in one dossier, and no witnesses were heard. I'm saying so for the benefit of maybe non-lawyers, so that you can already prepare your written submissions on the basis of the documents on record and the pleadings and the affidavits. There was, and there still is, I would say unfortunately, a certain reticence from the bar to follow that lead. I can understand why, because it's very time consuming and it's very demanding, the more so since we are confronted with sometimes very short delays to be able to put in our submissions.
Yes.
But I, for one, as you said earlier on, the fact of teaching and so on, has enabled me, if you want, to develop this skill maybe and the love for writing, for discoursing, for, making it such that the law should also advance. It's not just to address a particular point that is before you, but it's also to see how we can make things advance. Maybe that's a deformation of having appeared before the Privy Council a few times, where they did not just state the law, but given the opportunity, they will also stretch their thought process to what, the future could be. So therefore, what I feel is that more time would need to be devoted now to written submissions and less time spent in court. So this is already a reality. Formally, let me say that maybe for those who may not have known how it was, I'm not going to say 40 years ago when I started practicing, but even 15 years ago, I was close to that. You came, you submit for how long as you wish. No written submission would have been furnished to the court in advance, and you just read out your written submissions. Right. Yes, I've seen counsel reading out, very senior counsel, and then once a question is put to them, you'd laugh. They put their finger where they were stopped, and then they continue reading as if nothing. Well, this is something which is unheard of before the Privy Council, or
in other countries for that matter.
Or in other countries, or even now in Mauritius, I must say. Now there is more and more an interaction between the bench and the bar.
Yes.
Why? Because written submissions would have been exchanged between counsel and the bench and communicated to the bench prior to the hearing, so that issues are narrowed down. You see? So that was the way it was up to a quite relatively recent past. Where you came, it was a monologue. Then you have a monologue on the other side. Then you have almost no interaction from the bar, or even action from the bench. And that's it. You are told judgment reserved, and then a judgment comes, maybe not even addressing any of those points. I mean, maybe harsh in my remarks, but that is the way things were. So with the advent of written submissions, and also of the fact that you needed also to reply to your colleague, there's also a right of reply which you could. So this would funnel down all the lines of argument and many a time of the superfluous arguments.
Yes.
Yeah.
Yes.
So there is that change. So hopefully, my own view is that we should, at the risk of shocking maybe some of my colleagues, shorten and limit the time of oral submissions.
Like they do before the Privy Council. They
Privy
tell
Council.
You've got 1 hour.
Exactly.
Yes.
Exactly. This being said, Joanne, I must add for good measure something, is that oral submissions should and can by no means be substituted by written submissions. As sometimes for some courts we find it. No.
Okay.
There should always be a slot, as you said, to be able to be apportioned, to be able to be thought out by the court or by the court manager, as we do in the Privy Council. They've read all the brief and they know exactly how much time should be allocated to which party. Yes.
And also, I guess, also to come back to the kind of the certain prestige associated with being a barrister, if you did purely written submissions without any interaction, without any advocacy, you kind of lose the art, because it's an art as well. So you should have a balance of both, I would say.
Well, look, from my own experience, be it before the Privy Council or in Mauritius here, I have an appeal tomorrow, for instance. I'm not going to argue all the points.
Of course.
You see?
Yes.
I could.
Yes.
the court would give me the latitude to do
Yes,
so.
yeah.
But with all due respect to their intelligence, I have already submitted my written submissions. And I know, and this is where the sense of value judgment as an experienced barrister should come in, or even less experienced, where you'd say, look, I'm of the view that this case will turn on those two grounds, and this is what I'm proposing to address. Then you give quality time to those two grounds.
Right.
Whereas the other grounds, they have been already catered for in your written submissions. You see, this is the technique to do it. Should the judges have any questions, they will ask you the questions on the other ones.
Other grounds, yeah.
So then, the end result is what? In not proceeding this way, you're doing a disservice to your brief and to your client, and to the court, for that matter. As we say, the scattergun approach should be avoided at all cost. I believe that, and this is where the intelligence, I don't mean to say the intelligence in the sense of being derogatory to those who do not,
Of course.
use it in this sense. No, this should not be interpreted this. I make this very clear. But the sharpness of approach, let me rather put it this way in a more neutral manner, should be that you treat the bench with the respect that it deserves. That, look, those other points have been said, but you know on what question or questions the judgment is going to turn, and you direct the court in that direction. You see?
Do you have the same approach before the Privy Council then?
I suppose I developed that approach from the Privy Council.
Right. Right.
Yeah. This is in fact the way they approach it. They already give you an indication as to what the case is going to turn on. They ask you the questions. You've watched so many appeals, and understand you will be there very soon also. I wish you all the very best. No,
I might have to, pick your brains closer to the time.
By all means. I have a few minutes after this podcast we can discuss. But to come back to that, this is the most humbling exercise that can happen to a barrister appearing before the Privy Council. Everything is set to ground zero. Everyone is treated on an equal footing, and no one's reputation precedes him or her. This is the beauty of it.
Because you could be asked, I've obviously watched some, including in the case of Shophold, where you appeared.
Yes.
It was very good. Excellent judgment as well.
Thank you.
Have you had situations where actually you were not expecting some of the questions at all, and you felt not unprepared, but for a second, you felt, what am I going to reply to this?
I've appeared before the Privy Council on 5 occasions.
Mm-hmm.
4 of them were successful. 1 of them was a test case, so I already knew the outcome.
Okay.
But nonetheless, it was a very interesting case. It was the question to be determined in law regarding the dichotomy between the civil law about code civil and the labor law regarding a contract of employment.
Right.
Which trumps which? Is it the law of contract, or is it the Labor Act? Now the Employment Rights Act. So that demanded a lot of research. I had to kind of write a mini thesis on the evolution of the contract law of employment and also of the labor. And that was well taken by their lordships, so that the result didn't matter. Right. But at the end of the day, it was the statement of the law. Each case presents the same features. You see? You need to captivate their attention and their curiosity, because many of those areas of the law are new to them.
Of course. And
they will respond favorably. So now to answer your question, before going every time at home, I received a very severe warning. Look, listen to the question, because when we ask you questions, you never
I can guess who the warning comes from.
You are very absent-minded. Yeah. Listen to the questions. Well, the answer to the question is that they demand an answer. Don't beat about the bush. Right or wrong, give them a firm answer. But bearing in mind that there will be follow-on questions. And those questions will bring you in a particular direction, which can be a cul-de-sac, a point of no return, in which you would have destroyed your own original argument.
Yes. But do you see it from a strategic point of view? Do you see it coming 5 questions before? So when they ask the first question, can you gauge in which direction they're trying to steer it?
You can, but at the same time, you should not be too much on your guards and be wary, because they're not
trying to catch you out. They're
catch you out, nor to entrap you. No, nor to entrap you, because you can always go back and qualify what you stated.
Of course.
So before the Privy Council, the technique is altogether different in the sense that it's not just about these facts and that particular case. It's more about the law regulating the whole of that particular subject. You see? Like in one case, Pierre Girard and Deby in that case. So that was a case that was heard in Mauritius. After the case was over, that was a question of the precedence to be given to registration of a transfer of a title deed at the transcription and mortgages office.
Okay.
So on the facts of the case, I was rather comfortable because I had the benefit of 2 concurrent judgments from the first instance from our Court of Civil Appeal.
In the favor of your client?
In favor of my client, was then before the Privy Council responded. But the law lords, and in particular Lord Mans, who was one of the greatest minds I've come across, after the case was over, he sent a note to counsel with judgments of the Cour de Cassation of France attached, seeking our views on the impact of those judgments on that case. Look at that humility.
Wow.
Amazing.
And that was after it was heard?
After the case was heard.
He was doing his research and...
Exactly. So before they proceeded, so I wrote back a small note thanking him and then just to put a few notes, and those were taken on board in the course of the judgment. So it goes to show that he was not just concerned with, expediting a judgment to address the issue at hand. No, he wanted to state the law and so on, realizing that sometimes there are deeds of sale that are effected and there is a delay between which this takes place and the transcription. And what happens if someone else goes and makes a fraudulent sale in the meanwhile?
Yes,
which would trump which?
Of course.
So this is, and he referred us to the latest, pronouncements of the Cour de Cassation because he was fully conversant in French and in the meanderings of the French law and the jurisprudence. And
so that's one other thing that's always impressed me with them because of the nature of our law. We have a lot of French civil-inspired law.
Yes.
And to see them in action, speaking fluent French, interpreting Mauritian law, not English law, Mauritian law, of a large part of it, of which is French-inspired. I always found that tremendously impressive. And as you said, the humility as well with which they speak and they engage with counsel. No. What would you say has been your, obviously not just the Privy Council, but throughout your career at all levels of the judiciary, what has been your most memorable case and why?
I would say my first case before the Privy Council, which was the case of Ashok Jagnat and Raj Ringadu. That was a case where Mr. Jagnat, Ashok Jagnat, had appealed against a judgment of the Supreme Court of Mauritius, a judgment of Judges Lam, Changlin and Dema, whereby my client, Mr. Ringadu, had successfully challenged his election by way of a petition on the ground of electoral fraud,
Right.
electoral bribery. So that was a premiere in Mauritius for many reasons. Firstly, there's never even been a case that had gone so far as hearing stage. And secondly, because it was successful in the sense that it struck down the election of a member of the assembly on the ground of fraud, not forgetting that at the time that the elections were being held, that the campaigning, that the acts complained of were being done, Mr. Ashok Joknath was a minister of the government.
Wow.
Yeah, he was elected, but his party did not come to power.
Sure.
But all the same, it was in his capacity as a minister that the action was entered against him. So that was a grand premiere. The case was heard over 2 days before the Judicial Committee. My first time, I was not a senior counsel then. And what I appreciated is that their lordships were very attentive to the presentation I had made, because I had sought to demonstrate and had made yet again, in line with the attitude that is taken there, kind of a comparative analysis of the electoral laws of Mauritius, the UK, and the Commonwealth.
Right.
Okay? And there was one point on which we had laid emphasis. Although we had not cross-appealed, it was on the issue of standard of proof. Because except for us, all the other parties had stated that the standard of proof in an election petition should be one akin to the criminal standard.
Right. So beyond reasonable doubt.
Beyond reasonable doubt. The Supreme Court had found it to be an intermediary standard of proof, that is beyond balance of probabilities.
Right.
I did not agree with this finding, although we had won the case.
Yeah.
And it would have been pointless to cross-appeal because for cost implication, just in case we had not.
Yeah.
But I nonetheless took up the point, hoping that the judges would take it on board. And they did take it on board, notwithstanding the fact that we had not specifically raised it.
As a ground of
And this is, in fact, this is the beauty of the JCPC. They are master of their own rules, as they say. They are
Because
there.
I see that sometimes in the questions that they say, we've read your submissions, we've read your case,
yes.
your statement of case, we have understood the issues, but what I really want to know about is this. And it rejoins the question I asked earlier, do you sometimes get questions that you don't expect? And it is, as you said, it's the beauty of it, because it's a real échange.
Yeah. They put you the question once. Let me approach the answer a different manner, your question. If you beat about the bush and you're trying to
evade the question,
they'd put you the question twice. But there won't be any third time.
Really?
They'd cut off this rapport, because they would by then know that you're not, to put it bluntly, you're not worthy of their consideration, of their time. Because when you go there, you must meet them head on, you must answer the question. You're not there for the gallery, you're not there for anything else. Yeah, they are. That is why I'm told that there are quite a few of my predecessors and so on who've been there once and once only, and who vowed never to be there again.
Really?
Yes. Yes. There was even one of them who went half day, and he didn't even go back in the afternoon.
Are you joking?
No. I was admonished all that before I went. I said, well, I'll still go. I'll see how far and how many times I can endure it. Don't take this as don't take this as a usual warning, as the police would put it to you. It's very courteous, very proper, but in this sense, it's very harsh. And rightly so.
Yeah. They don't suffer fools.
No.
If I could
Rightly
use this
so.
expression. Yeah.
And these are questions that demand a minimum of mastery of your case file and of studying. See? You see, I did put the question to the law lords, because when they came to Mauritius, we had the opportunity to meet them. There was a get-together that was organized after their hearings at the Bar Council premises. And I put the question to a couple of them, said, how come you master our case file better than we do over such a short lapse of time? Because they normally take their case files on the Thursday,
right,
preceding the week where they're going to. Yes. They don't work on Fridays, then they go to their country house. So they have the whole of from Thursday evening to Monday morning.
Yeah.
And Monday morning they start their hearings later because they're coming in from the countryside.
Right.
Or wherever.
That's impressive.
Yeah. So the answer was that, look, we train ourselves, we remain very focused, and they also have the assistance of judicial assistants, who are normally the stars of the young bahus who are recruited fresh from university or from the bar, and who do a stint of 2 to 3 years, following which they get accepted at the top-notch,
Yes.
chambers.
I've got a really good friend who did that, a Mauritian friend. So he qualified as a solicitor like me, worked at a magical firm. Then I can't remember which judge it was, had the opportunity to do that. He did that for 2 years. And now he's a very, very successful barrister. So
Yeah,
he pivoted to...
I have met a couple of former judicial assistants, just by sheer coincidence also. One of them who was judicial assistant to Lord Brown in the Ringadu case in 2008. And she was telling me, and she remembered, of course, because that was one of the few cases, and she knew about Mauritius and so on.
Yes.
So that was one of the very few cases about Mauritius. She was telling me the way it goes that she writes the judgment separately from the law lord. Okay? She writes a judgment, he writes a judgment, and then they compare notes. Yes. This is how it goes, you see? This is the kind of latitude that they're given to develop their own thought process.
And it's an amazing skill that they're learning.
Yes. So speaking of mentoring, this
yes.
might be another avenue to explore.
Yes.
We have judicial assistants to our judges in Mauritius, as you probably are aware. So I do not know how they function, but this should be a welcome idea.
Yeah, to encourage.
Yeah.
So you've talked about the most memorable case. Have you had any case that you found, because we've had several barristers on this podcast, and I always ask them, particularly those who do some criminal law, how do you remain, or do you remain detached emotionally? How do you get through this? Because sometimes it can be quite draining. So have you had a case where it took a toll on you, emotionally, psychologically?
Well, every single case. Yesterday I had a matrimonial case. It was about, the custody of children of a couple which has been torn apart. And instantly I had my daughter who was a junior in the case with me. And then for a minute, she wasn't my junior, she was my daughter. When just so fleetingly. So we're human.
Yeah.
Thank God for that.
Yes.
And how much you try to rationalize and so on, but it does touch you somewhere. But obviously, you need to resist the temptation of actually playing into the hands of your client and allowing his sentiments to overshadow.
Or cloud your judgment.
Cloud your judgment. there are even I've done a lot of criminal cases also where you're tempted to think, did he or did he not do that? But this is not even a question that should cross your mind.
And this is not your job.
This is not exactly, you know what I mean? And there are many cases where also we have perhaps misjudged our client. Not that we should have judged in the first place. So we have to juggle with these realities, with these human dimensions. This is where, you see, the drama of a courtroom is now going to be reduced to a bare minimum.
Written submissions.
Exactly, with written submissions, with the shortening of witnesses and so on, testimony, video conferencing, where it's not palpable anymore.
It's a good thing. Yeah, I agree.
Yeah, you see, some people might argue the contrary. See? But again, the days of the long-winded submissions, of the discourses, these days are gone. Yeah. These days are gone. I'm tempted to say thank God for that. But we should nonetheless keep and maintain a certain measure of oral submission, of interaction with the bench, because this is where your persuasive skills come in, and the judges, they're open to persuasion. They're open to that. There are many times that you go. I'll share my own experience with you. Recently, in the case of Ecosud, which you are all aware,
of course.
When I argued the case before the Mauritius Supreme Court of Appeal, I was told that, look, the court is conservative. The court will not open the floodgates to allow, an NGO like Ecosud to be given a locus standi to challenge the project in question, where the aqua marine situation was under threat. And I said to myself, well, if I were to give in to that kind of predetermined state of mind, I might as well not be present in court.
Yeah.
I might as well withdraw the appeal.
Yes.
If I'm going to prejudge the judges, there were two judges, but it's pointless. Then I said, no, let's approach it with a very positive attitude. How? Very simply, to explain to the learned judges what task was befacing them. Namely, and I must confess that was maybe provocative on my part, but I had to do what I had to do. I said, well, are we going to remain in a time warp of the last century, or are we going to move forward? This is the task befalling your ladyships.
And it worked.
And it worked, you see. You need sometimes maybe to, be daring, because otherwise these judges, I'm not saying these two judges in Casque, but I'm talking generally here, might be tempted to just follow the precedents, okay, which they cannot necessarily be faulted for. Let me just say that. It's not necessarily a criticism. They would be justified, perhaps. But on the other hand, there is another avenue where you can advance the law. And this is I'm not talking of judicial activism here necessarily, but in a very restricted manner, yes, judicial activism.
Yes,
but
and
to be able to do
see
so,
that with the judgment of before the Privy Council
exactly.
as well.
But to be able to do so, you need to be in a very humble manner. You're not there to bang the table without any pretension, and to be able to explain, look, there's a very narrow room for maneuver, and we can do so in the name of the environment for the future generations, because if Ecosud, one NGO of that name, cannot do it, but who will speak for the mangroves if they don't?
Indeed.
The mangroves are voiceless, speechless, and the environment will keep on degrading. So that message was received loud and clear. I didn't realize it until the judgment came. You see?
Well, that's wonderful. And must be so, and obviously it was for a good cause as well, but it must be so, gives you a lot of hope as well.
It does. And in fact, in this case, I must place for the record the immense contribution of our friend Anne-Sophie Julien. Anne-Sophie and also our friend Hardy, the attorney, because it's Anne-Sophie who came to me, he approached me. And unhesitatingly, I said, yes, I will take up the challenge. And when we won, the ministry appealed, and Anne-Sophie came back. I said, let's go to London. Let's go to London. And there was also another King's Counsel there, another one, and also Sanjay also was there in the team. It was a jolly team. And we pursued the argument. Thankfully, the Privy Council was already very well versed, with this.
Probably had an inclination of which way they were going to lean as well.
Yeah. They had delivered a judgment not later than 1 week before that.
Right.
And also, you see, the myths in which they have studied Oxbridge, their education, their upbringing, and also respect for the environment. And also when we spoke of a pristine environment on a small island where there is no scope for further development and so on. So we touched the right chords.
Yes, indeed. We had just this week, we had the head of sustainability at the MCB group talking and we just had COP29, and also, I think it's easy to forget that we, as small island developing states, we're extremely vulnerable to climate change, and our ecological system is so fragile. I mean, we've seen with Wakashi a couple of years ago.
You see, so this is the message that should be put across before that particular forum. Each forum, you need to be able to see, but what is it that will, touch their sensitivity? Apart from the law, obviously you need to be law, but at the same time, there is that little something, that tipping point, because they want to know about the local realities. You see, what may be contextualized in Mauritius may not necessarily be so for the law lords in the UK. They are far away as they are.
Yes.
So maybe it can be the same for a small island off the north coast of Scotland, which is in the middle of the ocean like Mauritius. So this may be a reality which might be, consonant to their ears. So this is, I suppose, one of the greatest tasks that we need to be able to do, to transpose that reality within their legal reasoning and then ask them to apply it. However, this being said, some standards are universal.
Of course.
And there is no concession that can be made, because the ministry tried to make way for some exceptions in that case, and we said no. Standards are standards.
That's such an interesting take on it. I'd never, until you phrased it in the way you did, it's often very easy to get lost in the law. You have the way you conveyed that makes you look at things from a different angle, and sometimes it works. Yeah.
Poetic law, not poetic justice.
Exactly. Although we've had poetic justice recently, but we shan't talk about that. Last question for you. Sanjay, I often, again, ask that as a first question because one of the reasons for this podcast is to have a conversation with people who inspire. What drives you in life?
Life drives me.
Oh, good answer.
It's a call that comes from within. You see, when you wake up in the morning, I mean, you have a sense of purpose. There is, for instance, speaking of now, there is this case coming tomorrow. It's on contempt of court, and I'm going out there to inspire the judges to I like to see myself as a knight for the law, to write the law, to advance the law, and to show us what are the limits, and to seek justice. I'm still a dreamer, I suppose. You see, I mean, had it not been this way, I would not have put in that many hours of work. I would have delegated the work to my juniors and so on.
Yeah.
But I tend to all my written submissions personally.
Personally, really?
I do so personally. Well, I've been told, by some judges that, we know you write yours. Many of your colleagues don't write theirs, and we know that.
That's amazing. And I think I saw on your website that you once had a full bench of the Supreme Court, if I'm not mistaken, complimenting you on your skeleton argument.
And in that case, you make me have the shivers. I had the pupil I referred to you at the very beginning of our conversation, Joanne, who was then my pupil at the time we were preparing that case.
Right.
And when I rested my submission before the full bench, I turned to him and I said, "My Lord, my thanks also go to my pupil, Mr. So-and-so," not knowing that 25 years later,
he would be
that young gentleman would be one of theirs on the bench.
You're giving me goosebumps now. That's amazing. That is inspiring.
Yeah. No, as we said, it must be done with the heart and the soul. I mean, there is, as far as I'm concerned, this is what keeps me going, if that answers your question.
It does. Thank you so much. And I'm sure a lot of young barristers will watch this and be inspired too. Thank you for your time.
And my doors are always open to those who are listening. Come for a conversation, a cup of tea, and share. Let's keep sharing.
Thank you so much.
My pleasure.